So that what was the compromise reached between you and your father-in-law? Suppose आप आज कोई केस चल रहा है, आपको नोटिस भेज दिया, आप नोटिस के बाद नहीं अपीयर कीजिए और 1 साल बाद इस केस में कोई ऑर्डर पास हो जाए, then who will be responsible for this? On your own statement you fail.
This is an ex-party order. This is admitted, Your Lordship. This is an ex-party order.
It is an ex-party order for a valid reason.
May I kindly consider the.
It is an ex-party order for a valid reason. तो कुछ भी बहस मत कीजिए।
2 सप्ताह के बाद यही ऑर्डर।
नहीं, कोई सिंपैथी की बात नहीं है।
नहीं, सिंपैथी मेरे साथ नहीं, बच्चे के साथ सिंपैथी हुई।
अपने बच्चे को पैसे देने में इतनी दिक्कत हो रही है।
यहाँ तो सब वही कैसे जा रहा है, बच्चे को देने में दिक्कत है, वाइफ को देने में दिक्कत है।
This is father of opposite party number 2.
Yes.
And the petition under section 125 of CRPC was filed by Nana, Lordship, under the guardianship of Nana, the father-in-law of the petitioner. What happened, Your Lordship? And the wife of the petitioner died an unnatural death on 10/7/2017. Petitioner was taken into custody. And then the Nana of the opposite party number 2 took the son of the petitioner to his place. And the petitioner has been acquitted, Your Lordship. I have annexed the order. After that, the petitioner wanted his son back, but he refused and asked him to pay maintenance. Initially he paid some amount, Your Lordship. I have annexed the money receipts, but he insisted that I should keep on sending money. Then when I refused, because my son is a special child, having several neurological problems, is mentally retarded or cerebral palsy patient. I have taken to CMC Vellore twice in 2015 and 16. I have annexed the medical documents. So Lordship, when I am ready to keep my child with me, he can't force me to give maintenance.
What was the compromise reached between
when I was acquitted,
your client and the father-in-law?
Your Lordship, earlier I filed a petition for custody of my child under Guardianship Act, Your Lordship, but our relatives made a compromise. And
let us come to that compromise order.
Lordship,
Page.
at page 18,
Yes.
आवेदक की ओर से वकालतन हाजिरी साथ एक आवेदन साथ शपथ पत्र अंडर ऑफिस और अंडर रूल 23(1) CPC के अंतर्गत प्रविष्टि कर प्रार्थना करते हैं कि आवेदक एवं विपक्षियों के बीच आपसी सहमति बन गई है, अतः इस वाद को आवेदक वापस लेना चाहते हैं। अतः इसकी
You should
अनुमति।
have enclosed the copy of the petition under order 23 rule 1 CPC. Where is that?
That has not been made available.
That would have only shown.
But the next page, Lordship, I kept on sending money, Lordship, to the
You
Nana.
were sending rupees 5,000.
5,000.
He is still minor.
So, Lordship, when the Nana of the child is not in a position to maintain
But
a special child.
you are unable to show that what was the compromise reached between you and your father-in-law. You withdraw the case.
Yes.
You have withdrawn this guardianship case on 19/11/2019.
Sure.
And if you have withdrawn, it means you have given up your case for getting guardianship or the custody of the child.
But Lordship, under section 125 CRPC, Lordship, when the father of the child is ready to keep him with himself, Lordship, and ensure his proper treatment, the money which I have been sending, Lordship, that was not being used. That was not being used in the welfare of the child.
Come to the impugned order.
Lordship, परोक्त वाद भरण पोषण वाद आवेदक मोहम्मद अनस द्वारा धारा 125 दंड प्रक्रिया के प्रावधानों के अंतर्गत भरण पोषण हेतु विपक्षी मोहम्मद फिरोजुद्दीन के विरुद्ध लाया गया है। आवेदन संक्षेप में इस प्रकार है कि विपक्षी आवेदक का पिता है, जिसकी शादी उसकी मां तबसु नाज उर्फ डोली के साथ हुआ था, जिससे एक बच्चा मोहम्मद एनएस का जन्म हुआ। जो अभी 5 वर्ष का है और दिनांक 12/1/18 से अपने नाना के साथ रहता है। उक्त बालक मानसिक रूप से अस्वस्थ है, इसलिए उसके विशेष लालन एवं सेवा की आवश्यकता है। यह भी कहे कि विपक्षी की पत्नी की हत्या विपक्षी द्वारा किया गया, जिस पर आपराधिक मुकदमा दर्ज है तथा वह उक्त बाद में न्यायिक अभिरक्षा में था। ऐसी परिस्थिति में उक्त बालक असुरक्षित था, इसलिए आवेदक को नाना के साथ रहकर लालन पालन किया जा रहा था। विपक्षी का जोता का व्यापार हजारीबाग में है और वह उससे 50,000 रुपया प्रति माह की आमदनी करता है। इस तरह 15,000 रुपया भरण पोषण के रूप में उक्त नाबालिग बच्चे को विपक्षी से दिलाए जाने के लिए निवेदन किए हैं। विपक्षी की अनुपस्थिति हेतु सम्मन तथा पंजीकृत डाक से नोटिस निर्गत किया गया, लेकिन उसके बाद भी विपक्षी उपस्थित नहीं हुआ। अतः विपक्षी के विरुद्ध एक पक्षीय कार्रवाई प्रारंभ किया गया। अब न्यायालय के समक्ष विनिश्चय हेतु बिंदु यह है कि क्या आवेदक अपने वाद को साक्ष्यों के अतिसंभाव्यता के मानक पर साबित करने में पूर्ण रूप से सफल रही है। आवेदक अपने वाद को साबित करने के लिए 2 साक्ष्यों।
Do you have a copy of the compromise petition which was filed?
Not been made available.
That would be very important.
But Lordship, may kindly consider, Lordship,
Why
I have
didn't
annexed
you appear in the-
I have annexed the medical document.
Why didn't you appear in the court below?
Lordship, for the first time I came to know about this order when I received a notice under section 125 of the CRPC, which is for enforcement of the order. In fact,
Where is your statement to that effect?
yes. ऐसे आइए पिटिशन में तो मैंने पहला पैराग्राफ लिखा है कि the petitioner
There is
gave
no ground at all in your petition. There is no ground taken in your petition that no notice was served upon you. And the order suffers from violation of principles of natural justice or the procedures which are required to be followed. आप देखिए, not a single line is stated.
Yes, Lordship, paragraph number 9.
Paragraph number
9.
Paragraph number 9.
9 at page 5 of the petition, Lordship.
Paragraph number 9 is not a ground.
But Your Lordship, in this case, it has been stated that the said notice issued on 5/3/22 was received by the petitioner on 9/3/22, and only through this notice the petitioner came to know about the order dated 23/12/21.
You came
passed
to know
against him.
about the order. Please see the kind of language which you are using. Very carefully you are using certain words.
Lordship.
No, I am telling you, you came to know about the order for the first time after you received the notice. You are not saying that you came to know about this case only after passing of the order, or that during the pendency of this case you had not received any notice.
Maybe, Your Lordship.
Please see the kind of language which you have used.
Because before this date, I was not at all aware of the order, Your Lordship. That is why it
Order
has been
you
said.
may not have. Suppose आप आज कोई केस चल रहा है, आपको नोटिस भेज दिया, आप नोटिस के बाद नहीं अपीयर कीजिए और 1 साल बाद इस केस में कोई ऑर्डर पास हो जाए, then who will be responsible for this? Whether court should again send you a notice with a copy of the order?
But Lordship, one thing is admitted that this is an
On your own statement you fail.
This is an ex-party order. This is admitted, Your Lordship. This is an ex-party order.
It is an ex parte order for a valid reason.
May I kindly consider the
It is an ex parte order for a valid reason.
may I kindly consider the plight of the child.
Kindly consider the plight of the child. I am also saying. You
This
are
crucial
a
child,
husband who were being prosecuted.
Twice he was taken to a Lordship hospital at Hellore. I ensured a Lordship a treatment. And now,
2-3 things are going against you.
Lordship,
First of all-
the 5,000 rupees which I have been sending was used by his Nana for his own purposes.
I
That
don't
is
know.
why, Lordship, that amount was just stopped.
I don't know.
Lordship, his Lordship, old Nana is not able to, Lordship, take care of a special child. Cerebral
That is your mere bald statement before this court. That has no basis.
Lordship,
Why the court take into
The chi-
consideration such facts which are not on the
the-
record, which are not proved even prima facie by you?
Lordship, mother of the child is not alive. I did not contract any marriage after the death of my wife. My child is special. And Nana is insisting you are sending 10,000 rupees so that
Why
he may
did you
use.
give your application for guardianship? You withdraw your application for guardianship. That too on a compromise. You have agreed. You have agreed to allow the boy to remain in custody of his Nana.
Well, Lordship, I will bring that petition on.
Is it not? You have allowed the boy to remain with his Nana.
Lordship, had that been the case, then amount was not being used in the welfare of the child. That is
That
why,
is-
Lordship,
please try to appreciate how
kindly-
the court can take note of these submissions.
let you kindly.
These are not the matters which the court has to decide on the basis of mere affidavit or on mere statement. I am not sitting in writ jurisdiction where the plea is to be considered on the basis of affidavits.
Lekin kindly, Lordship, may kindly appreciate the old Nana. Lordship, even if 10,000 rupees is given to the child, he will not be able to, Lordship, ensure his proper treatment at welfare, Lordship. And I am ready to keep my child with myself. I will ensure his treatment. Only because I went to the custody and Nana took
फिर
the
आप
child
एक
with.
सवाल का जवाब नहीं दे रहे हैं ना आप
हुजूर, वो मेरे
हमेशा
पास-
चाह रहे हैं उसी। आपने जब गार्जियनशिप का केस फाइल किया
जो पिटीशन हम रिकॉर्ड पे ला.
तो आपने उसको विड्रॉ कर लिया एक कॉम्प्रोमाइज के आधार पर एंड डेफिनेटली कॉम्प्रोमाइज वाज दैट द बॉय विल रिमेन इन द कस्टडी ऑफ हिज नाना
तो
सो यू हैव एग्रीड फॉर दैट कस्टडी
एक मौका दे दिया जो उसको हम रिकॉर्ड पे ला दे रहे हैं, लॉर्डशिप, सो दैट लॉर्डशिप ने काइंडली.
that will this is how the cases remain pending. These are the reasons why the cases remain pending. जब आपको एक क्वेश्चन होता है ना, नहीं आप अकेले नहीं हैं, जब भी एक क्वेश्चन होता है आई कैन डिस्पोज इट ऑफ राइट नाउ. आपने डॉक्यूमेंट नहीं फाइल किया.
I have, lordship, I have annexed the order, but since I have not annexed the petition and lordship wanted to see the petition, to a short adjournment may be allowed.
Tomorrow?
I will bring that.
Tomorrow?
1 week, lordship. Tomorrow he will have to come, lordship, from Hazaribagh. Then it will have to be affidavit.
लिखिए. Matter has been heard for some time. We'll stop. It appears that the petitioner was being prosecuted for the alleged abatement of suicide. 2 सप्ताह दे दिया.
इस पार्ट को पेंडिंग है ऑलरेडी 128 पे. पेंडिंग है पिटीशन. तो ये 2 सप्ताह के बाद जो ऑर्डर होगा
नरेंद्र कुमार सिंह
128 का पेंडिंग है तो क्या होगा उसमें? क्या होगा बताइए?
तो वहाँ हम अपियर कर गए हैं. वहाँ कोर्ट
क्या होगा 128 का क्या होगा
वहाँ
उसका
कोर्ट
स्कोप?
वहाँ कोर्ट बिलों का जो ऑर्डर होगा हम उसको कंप्लाई
तो ऑर्डर जब से अल्ट्रेशन होगा तभी तो.
हाँ.
आज की तारीख में तो ये ऑर्डर एग्जिस्ट कर रहा है ना. कोई भी प्रोपोजिशन टेस्ट कीजिए ना, वैसे बोलने से नहीं होता है. आप 128 में गए हैं तो क्या फर्क पड़ जाएगा उससे इस इम्प्यून्ड ऑर्डर को? अभी तो एज ऑन डेट इट एग्जिस्ट. Can this order be altered with a retrospective effect?
No,
It
lordship.
cannot be.
But since I have appeared there, so
तो कुछ भी बहस मत कीजिए.
lordship 2 सप्ताह के बाद यही ऑर्डर.
नहीं कोई सिंपैथी की बात नहीं है.
नहीं, सिंपैथी मेरे साथ नहीं, बच्चे के साथ सिंपैथी होगी.
अपने बच्चे को पैसे देने में इतनी दिक्कत हो रही है.
यहाँ तो सब वही केसेज आ रहा है. बच्चे को देने में दिक्कत है, वाइफ को देने में दिक्कत है.
कि नाना को देने.